again. This is Robert Nuddleman with the Nuddleman Law Firm, and we're continuing our discussion regarding wage and hour laws. I want to focus today a little bit on some of the information that an attorney is going to be looking to get during that initial consultation. And primarily, this could apply this is going to apply if you're the employee, but it also applies if you're the employer. Knowing what information to bring, what kind of questions are going to be asked will help you get your point across to the attorney. First and foremost, one of the things I need to know is what was the type of work that the employee performed. We need to know so we can determine, is this an exempt position? Is this a non-exempt position? How many hours are they working? Is this a skilled position, an unskilled position? So having a good idea of what they do. Having just a job title usually is not sufficient. Job description is much better, but also just knowing firsthand what it is that the employee does. We also need to look at how is the employee paid. Are we looking at an hourly employee, somebody that's paid a salary? Are they paid by the piece? Do they get commissions? Do they have bonuses? Are there any agreements that say how the employee is supposed to get paid? Employers now are supposed to provide what's called a notice to employee under Labor Code section 2810.5. Every employer, when they hire a new employee, is supposed to provide them a sheet that says how they're getting paid. Are they paid hourly? Are they paid salary? Are they paid, what's their overtime rate? Are they paid by the piece? Additionally, the employee is supposed to get a pay stub with every paycheck that indicates how many hours they're working, what they're getting paid for. Even employees that are paid on a piece rate are supposed to have pay stubs that show the number of hours, so the employee can look at it and make sure that they're getting paid at least minimum wage, and overtime is required by law. So I'm going to want to know, if possible, any written agreements, the past pay stubs, if there are any pay stubs, or if there are any other records, payroll records indicating how much was paid, what kind of deductions were made for taxes, etc. Overall, I want to know what kind of documents are going to exist. Is there this Labor Code 2810 notice, 2810.5 notice to employee? Is there a written agreement? If we're dealing with commissions or bonuses, is that commission agreement in writing? What does it say? Because the terms of that commission agreement are going to dictate whether or not that employee is or is not entitled to additional money. We also want to look at whether or not the person is a union member. If the person is represented by a union, they have a collective bargaining agreement or a memorandum of understanding. We need to look at those because the Labor Management Relations Act may preclude any kind of a wage claim. Sometimes if the collective bargaining agreement deals with a particular issue, then that may be the remedy. Additionally, depending on the Labor Code sections we're looking at, there are certain exceptions for collective bargaining agreements. I also want to know, are we dealing with a government employee or a non-government employee? Government employees, there's some dispute as to which of the which of the Labor Code sections do or do not apply. So always knowing who is the actual employer. Sometimes the question of who is the employer is not easy to answer because there may be multiple employers. You may have somebody who's employed with one company but working at another company who's farmed out to a third company. A recent change in the Labor Code actually allows an employee to bring a claim against anybody in that line of work, the primary employer, the person he's subcontracted out to, or the end client, for a wage and hour violation without even having to prove the usual elements of joint employer or alter ego. So those are the basic documents that I'm going to want to take a look at when they come in. If you're the employee, it's helpful if the employee already has a summary of this is when I worked. Are there time records? If there are no time records, how do we know what hours you worked? Pull out a calendar. Can we look at it and determine, well, I know that this was a really busy time, so I was busier here. Or I know I was on vacation during this point in time. And the same thing applies for employers, even if you don't have time records, which hopefully hopefully you do have time records, because really that's the only way to conclusively prove how many hours an employee worked. But even absent that, there may be other things that we can use to prove how often the employee worked. Are there security pads that they key in or out? Are there videos? Are there garage keying in and out for a garage? Can we look at computer logs to determine when they were logging on or logging off? So we also look at different ways to prove the number of hours that the employee worked. Thank you very much. This is Robert Nuddleman with the Nuddleman Law Firm.